Good morning, folks, and thanks for joining us for this virtual um, roundtable. We're calling them employee restrictions. How tight can you hold the reins? Um, that's as I thought about that this morning. It may be a little, maybe a little, I guess, critical of employers to suggest that they're reining their employees and you know, capitalizing on them on that way. That's not the intention of it. Um, Nonetheless, that is the title you see on your screen. My name is Chris King. I'm a lawyer with McInnes Cooper in the St. John's, Newfoundland, Labrador office. With me is an Amos-Stewart, who is a lawyer in the Moncton office of McInnes Cooper, and we both practice in the labor and employment group, the firm-wide labor and employment group. And I will say from recent exposure in person at our recent retreat, Anne has got a fine beanbag toss skills. We had a little tournament amongst our group, and I'm proud to say I won third place. But I'm next time we're playing, I want Anne as a partner. So just a couple of housekeeping items, and it was to note it was beanbag toss, which is different from cornhole, which both of games are wonderful, but this was a different game. I just want to put that out there on the record. I also want to put on the record that we can only see each other and we can't see anyone else. So this is very awkward, but these are the way that webinars go. And we're going to assume that everyone is not asleep and is hysterically laughing at our comedic prowess throughout the next hour. We will have your mics muted, however. So if you have questions, we'd ask you to put them in the chat of the GoToWebinar platform. You should be able to find the chat, and we will encourage your questions, and we'll accept your questions, and we'll answer your questions at the end of the presentation, assuming we have time, which I think we will, because this is not a hugely dense subject matter. So, how tight can we hold the reins? Maybe we'll switch to the first slide, Anne, and just talk about the concept that we're going to sort of touching on here is the evolution of employer restrictions on employees and what employees can and cannot do in and particularly after the employment relationship breaks down. Anne and I will get calls and inquiries from clients, employer clients, who say, look, someone just gave their notice, or someone is getting fired. We're concerned about what they might do next, whether it's use our information or solicit our customers, solicit our employees, go to work for a competitor. And this is not a new problem. It is very much an old problem. And we're speaking of course, from the perspective of employers, because we're counsel for employers. It's an old problem and a long-standing issue for employers that dates back, I'll say hundreds of years in the common law. There is a seminal case out of England called Nordenfelt, where that was an early sort of written decision about the expectations for employers in crafting agreements, if you will, with employees. And essentially, as early as the 1800s, the courts were saying it's a totally valid thing to do. It's a valid thing to protect if you're an employer, to protect your business or your organization by imposing expectations and restrictions on what your employees can and cannot do, but only within reason. So you have to be reasonable and only restrict to the extent necessary. It's generally referred to as restraint of trade, which means prohibiting individuals from going to the marketplace and seeking employment and being gainfully employed. So it is a concept that employers have been grappling with, and the case law has been developing over the over the course of the last couple of centuries. And the sort of the old solution has always been to craft employment contracts that are very restrictive and are sort of binding the hands of the employee very, very restrictively. And we've seen, particularly within the past 10 years, I'll say, we've seen a real development in the trends and in the law where the courts are becoming more and more interventionist in this area and are more and more willing to side with the employee, generally because of the imbalance of bargaining power in the relationship. Courts are routinely now striking down employment contracts, and if not the full contracts, then striking down these restrictive covenants, non-competes and non-solicitations and whatnot, on the basis that there was an imbalance of bargaining power at the time that the deal was struck. The employer has far more power in this relationship, and we're not going to hold the employee to such restrictive covenants. And there's no genetic reason for me to be bald. I am bald purely by tearing my hair out from the decisions of our courts that regularly tell us, employment and labor lawyers, that the employment contracts and non-compete agreements and those types of contracts that we put in place 5 years ago, which were perfectly good and valid at the time, are no longer perfectly good and valid because of some new principle that the courts have developed. So it's an area to stay on top of, and there's a particular reason why we wanted to hold this today, which we'll talk about a little bit more under the Competition Act amendments. But effectively, just tracking back, then, if we look at the way that the law has developed in the next slide, Anne, we're talking about these types of principles that are implied in every employment contract. Even if there's no written employment contract, there's always a contract of employment implied at law, and the law has developed these concepts. And these are still good concepts, but we're here to tell you that you also need to sort of work these into written contracts where possible. The idea that there's a duty of good faith and loyalty, some call it fidelity, to your employer, that every employee, while employed, cannot be actively competing with or undermining their employer, right? They owe at law the obligation to put the employer's best interest at heart and work to achieving that goal. And in exchange for that, they get paid money. So it's an obvious and a pretty fair deal. And it would be an affront to that for employees to be actively competing by working for a competitor, or scheming, if you will, and planning to go to work elsewhere, or to take the employer's information and start up their own shop and go to work elsewhere. So these concepts included along these is the fiduciary duty. Of course, fiduciary is a little bit different, and it's triggered when there's this particularly sensitive and special relationship between someone who might be on the board of directors, for example, or otherwise in a position of authority, and where the organization is in a real vulnerable position, that the organization has to sort of on blind faith assume, as they're entitled at law, that the individual is acting in their best interest. So that's a fiduciary duty. And then obviously the duty of confidence relates to confidentiality and the requirement for employees not to use information that they've obtained, whether it's trade secrets or specific proprietary confidential information, and then take that and use that either to compete or in any other fashion that's not authorized. These are all important concepts that I think we all generally understand, but there's been some interesting developments in in the law over the years. There was a case in 2008 out of the Supreme Court of Canada. So the events occurred well before that, but it was out of a small town in British Columbia where the entire staff, with the exception of 2 or 4 of RBC Dominion Securities, basically planned and executed a mass exit, and they all walked across the street to Merrill Lynch, taking with them confidential information which they had gathered up, and for the intention of using it, right? These are investment clients, and they all went across the street to Merrill Lynch, completely devastating that office of RBC. And in that case, of course, the trial judge, as confirmed by the Supreme Court of Canada, said that is an egregious breach of confidence when you are the office manager and RBC Dominion Securities is relying on you to right the ship, right, and lead the ship. And what you're doing in the background is planning with your staff and collecting the information, and then walking out the door one day with no notice and bringing all that information to your competitor. That is an egregious breach of confidence, and the outcome of that was hundreds of thousands of dollars in damages to Merrill Lynch for inducing that breach of confidence and breach of duties, and $1.5 million in damages against the person against the branch manager who orchestrated it all. So these are significant penalties, significant consequences if they are breached, and the law keeps sort of evolving in that area. I'm going to take a breath, Anne. Over to you.
Thanks, Chris. Good morning, everyone. Nice to be with you. My colleague Chris just talked about a series of unwritten rights and obligations. And so, as he mentioned, that's the stuff that exists without having to put anything in writing. But protections can be and often are created through written contracts that are additional to what's available to businesses as a result of the common law and equity, because they do offer limited protections. And the 3 sort of key contractual protections are what you see up on the slide here: non-competition agreements, non-solicitation agreements, both with respect to employees and customers, and sometimes beyond that, suppliers and contractors, etc. And also confidentiality agreements, and these are what is referred to commonly as restrictive covenants. And Chris mentioned the concept of restraint of trade, and a restrictive covenant is a restraint of trade. They're frequently found in employment contracts. Obviously, that's what we're talking about here today, but also in agreements for the purchase and sale of a business. And so a restrictive covenant will prevent the seller of a business from doing certain things that could harm the purchaser after the sale. And in an employment contract, a restrictive covenant will prevent an employee upon leaving employment also from doing certain things that could harm the former employer. And it's natural to think at first glance that you as a business, you should have one of these, one of each of these in place for every employee. Try to get the highest level of protection possible. But if you take a closer look and really sort of turn your mind to it on a case-by-case basis, it's rare that you actually do need a non-competition agreement for an employee. It's not a never situation, but it's rare. because in almost all cases, non-solicitation and confidentiality obligations will be sufficient to protect an employer's legitimate business interests. And that's where the question of legal enforceability comes into play. So there is quite a high hurdle for enforceability of non-competition agreements in particular. It's less difficult to enforce non-solicitation agreements, but still difficult, I would say. And typically you won't run into an issue with confidentiality agreements, because those are seen to be more reasonable. There's a lower threshold for reasonableness. So restrictive covenants are subject to a legal presumption of unenforceability. And what that means is that under the law, the starting point is that restrictive covenants are not enforceable. It's then up to the party trying to rely on the restrictive covenant, so the employer, to show why it should be enforceable in the circumstances. And reasonableness is the test to be applied in assessing the enforceability of a restrictive covenant. Regardless of enforceability, many employers include restrictive covenants for deterrent purposes. So they say, well, we might not be able to enforce this, but we want to make somebody think twice about doing something after they leave employment. And we'll talk more about the wisdom of that approach, the deterrence approach, shortly. But getting back to the enforceability threshold issue, and Chris alluded to this a little bit, that restrictive covenants give rise to a tension between the concept of freedom to make contracts and public policy considerations against restraint of trade. And restraint of trade, these restraints are contrary to public policy because they do interfere with individual freedom of action. And because the exercise of trade should be encouraged and be free. However, a recognition of the freedom of people to make contracts requires that there, of course, be exceptions to the general rule. And the exception is in every case, the only exception is where the restraint of trade is found to be reasonable. And in that regard, we just wanted to differentiate between a contract for the sale of business and an employment contract in terms of enforceability, because the absence of a payment for goodwill that takes place in a sale of a business, as well as the generally accepted imbalance in power between employee and employer that Chris mentioned, that justifies more rigorous scrutiny of restrictive covenants in employment contracts compared to those in contracts for the sale of a business. And so we're, of course, focusing on restrictive covenants in employment contracts today. So a court will only enforce an employment restrictive covenant that goes no further than is reasonably necessary to protect the employer's legitimate business interests and doesn't unduly restrain an employee from using their skills and earning a living, essentially. So it's helpful to think about some general principles when we're assessing restrictive covenants. And so keep in mind that to be reasonable, a restrictive covenant has to be all of the following things. So clear and unambiguous, relating to, as I mentioned, protecting the employer's legitimate proprietary interests, and reasonable in terms of geographic scope, time, and the activities being restricted. And in doing a reasonableness assessment, you look at a few different things: the nature of the work that the employee is doing, the role that the employee has with the employer, the nature of the restrictive covenant itself, and the context and some of the other terms of employment. And the reason it's so important to look at restrictive covenants on a case-by-case basis rather than using boilerplate language that applies across the board to your employees is because typically you only get one kick at the can. If there's something wrong with the restrictive covenant, then the whole thing is out the window. Courts don't want to cut out the unenforceable bits for you and leave the rest. The whole thing disappears. So you need to get it right from the beginning. So in terms of the reasons for using a restrictive covenant, what you're not allowed to do is use a restrictive covenant to improve a competitive market position or just to prevent the employee from competing with the employer. You can use restrictive covenants to protect confidential information, to protect relationships with customers and other trade relationships, and to protect goodwill. So if you've decided, you've thought about it, you've decided you're going to use a restrictive covenant, now you have to look at what it's going to say. And that's where we get into those three last sort of sub bullets there in terms of the scope. So looking at the geographic scope, a non-competition clause has to have a geographic scope, and the more narrow it is, the more likely it will be enforceable. So don't say it applies in all of Canada if you don't have any competitive threats in the Northwest Territories, for example. The courts want to see that you really turned your mind to where your reasonable competitive threats exist, and that you've identified that area in your agreement. So really, the employer doesn't have a legitimate interest in prohibiting activities where the employer doesn't operate. And that's regardless of the global nature of a business. Now, when it comes to a non-solicitation clause or confidentiality clause, you don't typically, you wouldn't need a geographic scope, but be careful that you're not dealing with a non-competition clause masquerading as a non-solicitation clause. Like if it says, you employee, you won't solicit customers or sell anything to them. That's really a non-competition prohibition, and you will find that in some clauses that are labeled non-solicitation, so beware of that. A time scope is required for non-competition agreements and non-solicitation agreements, but not for confidentiality agreements. Those can last in perpetuity. The restrictive period should last no longer than is necessary for the employer to secure its relationships, whether with other employees or contractors or suppliers or customers, as the case may be. And you need to be able to justify why a particular period was chosen. And then in terms of the activities that are prohibited, those have to be as narrow as possible, and they're assessed based on the time that the clauses, the contractual language was created, not at the end of the employment relationship. So don't try to include, future areas of business in your clauses. It's about what's happening at the time that the clauses were made, and then make sure that you're not trying to prohibit activities that the employee didn't do during their employment with the employer. So an example is, I believe it was a British Columbia case where an executive at a bank, the restrictive covenant was found to be unenforceable because it said that he couldn't go and work for a competitor, and the court said, well, it didn't say he couldn't go to work for the competitor as an executive. It said simply he couldn't go to work for a competitor. And why shouldn't he be able to go work for a competitor as a janitor? So you need to make sure that you're narrowing the activities as much as possible. So really think about what it is that this person could do to harm you, and just limit your restrictive covenants to that. And so, I mentioned non-competition clauses will be almost always unenforceable. The exception will be where the employee gains such information about and relationships with the employer's customers that they could undermine the employer's business, even if they're prohibited from soliciting the customers and using confidential information, because maybe the customers are going to go to that person regardless. And where that will be appropriate will depend on a lot of things, a variety of factors, sort of looking at how long the employee's been there, what the relationship was with the customers, you know, how much work the employee was doing with the customers, you know, the strength of customer loyalty. So those are all different considerations that you want to have. So that's a brief look at what was and what is. Looking into the future now at some trends, starting with the recent prohibition in Ontario against non-compete agreements with respect to employees. While Ontario is currently the only Canadian jurisdiction to prohibit non-competes by legislation, we expect it won't be the last, so employers in other jurisdictions should be prepared. We often see developments in employment law start in Ontario or BC, those larger jurisdictions, and then make their way across the rest of the country. So as of October 25th, 2021, a non-compete agreement with an employee in Ontario is void unless the employee is an executive or the employee has sold or leased the business or part of the business to the employer, and in the context of that transaction became an employee of the business. So be looking out for similar legislation in Atlantic Canada, as we will be, and we will keep you posted on that.
Yeah, I think that I think it's only a matter of time, and that the rest of the country follows suit. I think every jurisdiction it's coming, right? It's coming. We've had comments of this nature that, you know, dating back 100 years or more from the bench, from the courts. Now we have legislation in Ontario that says, look, except in very minimal circumstances, we're not going to allow non-competition agreements. It restricts people from the free flow of, you know, market labor, and that is harmful to the economy in effect, right? That is harmful to everyone, and we need to open that up. And so the starting point in Ontario now is there's a legislative prohibition. You are not permitted to enter into a non-competition agreement unless it involves an executive, someone they've called an executive, or the other carve-outs that Anne spoke about. But interestingly, I've been speaking with some colleagues in Ontario, and they're saying there's some creative things going on with employers trying to characterize everyone as an executive, right, and calling them a chief floor sweeping officer or whatnot, so as to bring them within the concept of an executive and have this non-competition legislation not relevant to them. Very interesting. We'll see how that plays out. But I think that we should all be prepared in the near to medium future to in all of our respective provinces to see this coming. Another very important trend that we've seen, and I would suggest a lesser known trend, although quite an important one, is recent changes to the Canada Competition Act. And before you slip into a coma here, just bear with me while I say that effective tomorrow is when these provisions come into play. Any unrelated employers who make an agreement to either fix the wages or salaries or other terms of employment, so as to have that agreement that their own wages will be suppressed, or have an agreement not to poach each other's employees or not to hire each other's employees, that will be in effect a criminal offense. And the penalties for that can be in the millions of dollars for employers, organizations, and it can be up to 14 years imprisonment for those who are coordinating those types of arrangements. So this is new. It's very important. It is not uncommon. It's certainly not common, but it's not unheard of for employers to have a handshake and an agreement that says, look, I know we're in competition, but you don't hire my employees, I won't hire your employees, and Bob's your uncle. Well, if after tomorrow, if those types of agreements are made, even off the cuff, or there could be an understanding or a phone call, that could potentially be a criminal act that's covered under the criminal conspiracy provisions of the Canada Competition Act. Very, very significant for employers, and I think something that has been flying under the radar to a great deal. If you wanted to just Google the Competition Bureau, Canada Competition Bureau website, you'll see some explanatory little videos. They're only about a minute or half a minute. And so it's very important, right? And so the no poaching agreement. I mean, I know of clients of ours who have had that arrangement, and it's also not uncommon for friendly competitors to just compare notes, right? Just to talk about, hey, what's going on in your shop? What are you paying people? What benefits do you give? Because they're all competing for the same individuals. I can think of my own circumstance when law firms are interviewing law students. There's a lot of communication. Now it wouldn't rise to the level of saying, well, let's suppress wages. That's not what's happening. But those conversations are getting closer to what we're talking about here, which is any agreement between two or more unaffiliated organizations to wink, wink, nudge, nudge, let's keep the wages down, or let's ensure that the other terms of employment are balanced between us. That will be a criminal offense as of tomorrow. Likewise, I won't steal your employees if you don't steal mine. Any agreement like that will be an offense as of tomorrow. A couple of, I guess, carve-outs. Well, I guess I should say that employer, in this case, employer is very broadly defined. Okay, so it means any director, officer, agent, or even an employee who is doing this on behalf of the employer. So HR professionals or any employee who is entering into and is able to bind their employer to this bilateral agreement or multilateral agreement can be getting the employer into hot water. So everyone needs to sort of take stock and have a conversation within your workplace about the importance of not engaging into that type of agreement. Pre-existing agreements are fine. So if those agreements existed prior to tomorrow, they will not attract that liability under the provisions, and that's spelled out and says, anything that existed prior will not be a problem. However, if there was a natural expiry of those pre-existing agreements, or if the parties agreed to re-up or reconfirm that pre-existing agreement, well, now you're falling right back in under these provisions, and it's potentially criminal. I would say it's alarming enough because I'm aware of and familiar with clients who are friendly competitors and are having conversations with their competitors in and around this concept. It only relates to unrelated employers. So, for example, two companies within a group of companies that are related, under like subsidiary companies under the same umbrella, it wouldn't relate, and that's for obvious reason. You wouldn't want to put restrictions within the umbrella, X group of companies. They obviously will not be bound by this, and there can be agreements, to the extent that you even call it that a person wouldn't leave one company and go to an affiliated company. So there can absolutely be agreements in that regard. Similarly, if there's a merger or acquisition, you can have agreements of this nature as it relates to those two merging or acquiring companies. So there is a sort of a defense there. Interestingly, in a franchise arrangement, so you can imagine two different franchise, let's say restaurants, they're technically not considered to be affiliated companies. So they would, if two of those sort of franchise restaurants were to engage into an agreement not to poach each other as employees or not to fix wages, that would on its face fall under this and potentially be criminal. However, the overall franchise agreement framework, it can permit this to happen, and that can be a carve out. So so that wouldn't attract the that liability. And likewise, if there's a secondment arrangement where one organization seconds an employee to another, there's always an understanding, if not a contract, about what is being paid for remuneration for that employee, what's being paid to the principal seconder, and that's a business arrangement that is also carved out from these Competition Act provisions, and it need not be, employers need not worry in that regard. But it's important to highlight, and we wanted to highlight that, and essentially these provisions are law as of tomorrow and attract very, very significant penalties for employers who are engaging in that type of what might have previously been considered innocent conversations to get information. I would say that the type of activities that would rise to the level of a criminal charge and conviction would be far, far, far more significant than having those types of conversations. But nonetheless, the Competition Bureau did just fine, was it Canada Bread, for the price fixing with the Weston Group. And I think there was like $50 million. The headline I read yesterday was like a $50 million fine imposed as part of a guilty plea there. So the Competition Bureau has a big stick and they use it occasionally. So that's what's happening in Canada. And then if we look to the US, south of the border, we're seeing that the FTC, the Federal Trade Commission, is now in the works of proposing to ban non-competes in all workplaces. So in the United States, it is very commonplace for any employment contract to have a non-compete element to it. It doesn't matter if it's a hair salon or a clothing store or a gas station or a tech company. It is standard operating procedure for employment contracts in the United States to have restrictions to say, if you leave this hair salon, you're not allowed to go and work in another hair salon. And these have largely been, in many cases, struck down. But of course, the employees don't know any better and are concerned that they're going to get sued. And the consequence of this is that a hairstylist is feeling afraid to leave their place of employment where they may not be happy and it may not be a functioning employment relationship. And if they do leave their place of employment, now they can't take their skills to another hair salon where they would obviously put their skills to work, or at least they feel that, and so they're being restricted. And the FTC is saying that, look, this is causing major problems. I'm going to quote from the chair of the FTC, Lena Khan. The freedom to change jobs is core to economic liberty and to a competitive, thriving economy. Non-competes block workers from freely switching jobs, depriving them of higher wages and better working conditions, and depriving businesses of a talent pool that they need to build and expand. So this is now the U.S. Federal Trade Commission saying we're moving in this direction. They were accepting commentary on this up until April. I have no reason to think that this will not be law, federal law in the U.S. in the coming months or years. But even going back, I mean, that quote that I just read to you is very similar to the same sentiment from that other case that I talked about from England in 1894, in which the judge said, the public have an interest in every person's carrying out their trade freely. So has the individual. All interference with individual liberty of action in trading and all restraints of trade themselves, if there's nothing more, are contrary to public policy and are therefore void. That is the general rule. And then that judge went on to carve out under what circumstances these restrictive covenants and non-compete agreements would be permissible. But it's striking to me that this is a concept that English courts were setting out, 125 plus years ago. And now we have legislation being passed in Ontario, and now the US seems to be moving in that same direction. This body of law has developed very, very slowly, but it's important to recognize that these are big trends. And so I would, and to echo what Anne said, generally speaking, there's no in almost all employment relationships, there's no real need to restrict a person from going to work elsewhere. A hairstylist, for example, a gas station attendant, a clothing store employee. There are only limited circumstances under which a person has such expertise and skills that them going to work elsewhere, even to a competitor, would be a damage to the employer that was justifiably sought to be prevented. So only in the highest level employees, those with the most skill, those with the most intimate knowledge of the inner workings of the organization, and withdrawing their employment alone would be damaging. So the point here that Ann and I are trying to make is, I think our general advice is stay away from non-compete agreements unless the employee is at the highest level. I hope I'm not speaking for you, Anne, but I think that's what we're on the same page, right?
Yeah, so absolutely. And I think Chris, you'll talk about some of the strategies for addressing these things going forward, and the advisability of sort of staying away from those non-competes and almost all cases. And the reason for that, well, we're going to get into the risks right now. Regardless of enforceability, as I mentioned, there's this idea, we'll put it in there for deterrent purposes. And as Chris was saying, in the States, referring to some of the employees south of the border, they might be scared to, go work somewhere else, go to another hair salon or another gas station. And so they stay away, even if those things wouldn't be, those restrictions wouldn't be legally enforceable. And at one time, we saw that approach as carrying little risk. Clients would say, I'll just throw it in there anyway. If we can't use it, that's fine. But maybe it'll, make John or Jane think twice about walking across the street. Well, that risk exposure is changing, and we'll look at why.
And I should have said, Anne, the FTC has basically quantified this, and they estimate that those types of restrictions on all employment in the U.S. it's a drain, or it costs the economy of the United States on an annual basis about $300 billion. And they're suggesting that if we can relieve these restrictions and people can freely flow, the economy will be to the benefit of $300 billion annually. So it's, to the extent that you can quantify these things, it's a striking number, and it bears our attention for sure. Sorry for interrupting.
No, and that's right, 300 billion US, and so here I guess that would be around $1 trillion or so, and with our exchange rate. So very costly indeed. So looking sort of more specifically at some of the risks, there's this 2020 wrongful dismissal case out of Ontario that's made a lot of Ontario employers uneasy about the enforceability of the termination provisions under their employment contracts. And in that case, what happened is that the for cause termination clause was void because it didn't comply with Ontario's minimum employment standards legislation requirements. And the court found that as a result of that void for cause or for just cause termination clause, the termination without cause clause was also unenforceable, even though it was a separate clause. I believe it was even in a separate part of the contract. And despite the fact that there was a severability provision in the contract, meaning that the contract said that you can sever or cut out any unenforceable bits and the rest of the contract is still okay. So this set a new precedent in Ontario and effectively voids many without cause termination clauses in Ontario employment contracts. And the decision also causes considerable concern to employers in other jurisdictions, including Nova Scotia and Newfoundland and Labrador, where the termination notice exception wording in minimum employment standards laws is substantially similar to that in Ontario, meaning the bar is higher in those provinces for an employer to be able to terminate without notice under employment standards legislation. Courts outside of Ontario aren't required to follow the Ontario decision, but the Ontario Court of Appeal, whose decision it was, that court holds strong sway across the country. And if other courts adopt the decision, then most termination clauses in employment contracts could similarly be rendered void and unenforceable, resulting in significant employer liability. So it's prudent that every employer review and, if necessary, properly revise their employment contracts to mitigate the risk that a court would find termination without cause clauses unenforceable. And if we look a little bit closer at the contractual defect in the Ontario case, the key lies in the distinction between the legal standard for a termination without notice for cause, which is a common law concept, and the higher standard for termination without notice under minimum employment standards legislation. So in Ontario, that standard under the legislation is where the employee is found to have been guilty of willful misconduct, disobedience, or willful neglect of duty that is not trivial and has not been condoned by the employer. And there are similar standards in Nova Scotia and Newfoundland and Labrador. Therefore, to terminate an employee under the Ontario legislation without providing notice, an employer might require more than just cause, as that concept is understood in the common law. And in many scenarios, what constitutes cause will meet the minimum standards in the legislation, but not always. And that's where the problem lies. So if your employment agreements in any of the provinces I mentioned say the employer may terminate your employment at any time for just cause without notice or pay in lieu of notice, you've got a problem on your hands very likely. So the Ontario case leaves the door open to legal actions for common law reasonable notice of termination or pay in lieu of notice. Which is almost always significantly more than what's required under employment standards legislation. And that's based on alleged defects in the for-cause provisions of employment agreements, even where the employment agreement otherwise properly, eliminated the common law reasonable notice. And so there could be, claims in provinces beyond Ontario on this basis. And then sort of moving beyond the idea of problematic termination for cause clauses, the risk doesn't just stop there. A 2022 Ontario case builds on the principles from that case we were just talking about, called Walksdale, and there the conflict of interest and confidentiality clauses in an employment agreement were the problem, and both those clauses said the employer could terminate without notice in the event of a breach of either of those clauses. So the court made the troubling statement that where an employment agreement is not consistent with the Employment Standards Act, it becomes invalid, irrespective of the actual arrangements made with an employee on termination. So that leaves the question, is anything in the employment contract that's contrary to employment standards, does that make the whole contract void? Because employment standards covers a variety of things, not just termination. So if the contract says the employee gets less vacation than they're entitled to under the employment standards legislation, is the termination without cause clause also unenforceable? We haven't seen that yet, but similar thinking around restrictive covenants in cases of wrongful dismissal, where courts have refused to enforce the restrictive covenants, where the employer has failed to provide the employee with notice or pay in lieu of notice of termination that the employee is entitled to. So it looks like restrictive covenants and termination notice should be separate, but nonetheless, we've had that result. So where do we go from here? What's the new strategy? Chris will fill you in.
Yeah, well, essentially, I think that our advice as employment lawyers is, there's really very rare circumstances under which non-compete agreements, non-compete elements of an employment contract are justifiable. And if they're ever called into question, you as the employer are going to bear the burden of demonstrating that this is a reasonable limitation in the circumstances, that it's only as broad geographically as it needs to be, it's only as long temporally as it needs to be, and it's necessary to protect your interest as the employer because of the particular unique circumstances of that person's employment and the potential risk that they bring from going to a competitor. So we would say that limit your non-compete agreements. If at all possible, ditch them. But if not, then limit them to the C-suite employees, right? Your chief executives and those officers who are in particular high level and unique positions. Non-solicit agreements are more justifiable. So entering into an agreement with an employee that says, look, if you leave us, you may go to work for a competitor, that's your prerogative, and we can't stop you, but you will agree not to solicit our customers or solicit our employees, right? If you're going to go work for them, you can't take our book of business or our employees and undermine, as happened in the Merrill Lynch case, and completely destroy our business. So those are much more justifiable. Likewise, confidentiality agreements that reconfirm. I mean, this principle is well established in law that says you are required never to disclose the confidential information that you learn in your employment. That's an obligation at common law, but re-upping that with an agreement to that effect would be very helpful. I wanted to just touch on a case that only came out last month, and it was out of Alberta, and it's a case called Catch Engineering, and they sued a former employee, a man named Mr. May. I'll call it May. M-A-I is the last name. So Mr. May was in effect an engineer, and what Catch Engineering did was they're a business out west in Calgary, who they provide human resources to second to the oil industry. And so this Mr. Mai was hired on. Catch negotiated this contract with Canadian Natural Resources, CNRL, and said, we have the person for you. He's our employee. We'll second him to you. He'll be embedded within your organization and take instructions from you, but he's our employee. And this is our whole business model. And we hire people and we contract them out for this purpose. It's not uncommon to what happens in Atlantic Canada, and certainly in Newfoundland, Labrador, in the oil industry. The interesting circumstances about that case was that Mr. Mai basically was throwing his weight around a little bit. He knew that his employer, Catch, had made a commitment to CNRL, and he, at the 11th hour, said, well, I want more money. So what was going to be a $90,000 a year job, salary job, he went in at the 11th hour and said, you're stuck without me and I want more. And he did negotiate more and got another 10 grand for 100,000. But in exchange for that, he signed an agreement that said, I'm not going to compete and I'm not going to solicit. Not that he wouldn't compete, but rather that he wouldn't solicit. And so for a year, he works for the organization, and then he tries to negotiate more money a year later, and his employer, Catch, said, we can't justify that. That's not within our business model, and so we're not going to pay you that additional money that you want. So he quits his job, and 3 minutes after giving notice to his employer, he sent an email to the oil contractor, CNRL, and said, hey, I'm hoping you'll hire me directly, and I'll cut out the middleman, as it were. And that's what happened. And when he was hired, the CNRL, I can't say that, terminated their engagement with Catch, and they said, we don't need you anymore. We've got the guy personally. So Catch said, that's totally offsides of your agreement. You've signed an agreement that said you wouldn't do this, and this is fundamental to our business model. And so they sued him, and they won. And it was only last month that the judgment came out, and the judge said, you've basically deprived this company. This is their business model. This is what they do. And in engaging people, they expect that they won't do this very thing. It's a very vulnerable position that they're in when they put people to work and they're embedded with these contractors, and it would decimate their business if we were to allow this. In that case, the judge noted there were some certain circumstances that justified upholding this requirement, these contractual restrictions. And one of them was that there was a more of a balance of bargaining power at the time of the contract. So I mentioned Mr. May. He sort of negotiated and pushed back and said, I want more money, and he got it. So there was more bargaining power than typical in that. And then the court also said, the circumstances here are such that the employer was way more vulnerable, so we can't justify this activity. So there's like I think it was $120,000 that the company was awarded, to be paid by the former employee for his egregious breach. He was essentially back channel working, competing against his employer to undermine their contract with the big company, and went to work that way. So there's a good example of, and a big win, frankly, for employers, that says all is not lost. You can still bind people in the right circumstances to these types of restrictions. I won't go on with the remainder of these points, but these are essentially elements that we believe as employment lawyers ought to be addressed in the contracts to assure, to the extent possible, that these contracts are enforceable. It is heartbreaking when, as employers, we provide these advice and put these elements into employment contracts, and then this case like Walksdale that Anne had referenced comes out, and we know that that's reverberated across the country. So now we have to regroup and revise employment contracts because of that. So that was the essence and the lay of the land, and I hope that's been of some value to see the trends in the law in this area, and where we're going, and how employers can protect their interests, because not despite the concept that there's an inequality of bargaining power and the employer has all the power, we know as employers that that's not the case, and there can be serious jeopardy if employees want to do us dirty. A brief note on MC Legal Lab, if you haven't heard of it, just Google it. You'll find it on McInnes Cooper's website. It's essentially in the labor and employment group. We offer at a fixed fee, about $1,200–1,300. We'll do a 90-minute session on a number of topics. I think we have 10 sort of standard topics that relate to accommodation in the workplace and respectful workplace, and everything from anything and everything to do with behavior and training for the workplace. So that's just a quick shout out for MC Legal Lab. It's the first of its kind in the legal marketplace, and we're kind of proud of it. So if that interests you, and a fixed fee for training up to 25 people, let us know if that interests you. Otherwise, I think that little thing was you can scan that with your phone, and that'll take you directly to my website, and you can download my picture and use it as your screensaver. Otherwise, and then we have our legal notes. That's it, folks. We're out of time. Thanks for joining us. We hope it's been of some value. And any last parting words or warnings?
No, I encourage everyone to set your picture as their screensaver, as I have done. No, thank you very much for joining us. It was fun, and we hope you enjoyed it.
Thanks. Bye, folks.